If you think estate planning is just writing a will and calling it done, you're missing about 80% of the picture. And this video is for you. A complete estate plan involves at least 6 different documents, and they all do different things. Today, we're going to break down each one of those you actually need, what each one does, and why skipping one could leave your family in a legal nightmare. So, one of the big ones is your will. A will is basically your instruction manual for what happens to your stuff when you're gone. It covers 3 main things. Who gets your stuff, like your house, car, and bank accounts, who's going to manage the process, and if you have minor children, who's going to raise them. Here's the catch. A will only kicks in when you're gone, and it has to go through probate, the court process that takes months or years. Your will doesn't help you if you're alive but incapacitated. Only about 30% of Americans have a will. So that means almost 70% are letting the state write their will for them through state law. A trust works differently. You can think of it as a container you're going to put all your assets into while living. And people create the trust because they avoid probate entirely. Your family gets assets immediately, no court. They're private. Wills become public record. Trusts don't. And you maintain control. You can be the trustee of your own trust while living. Now, there are 2 main types of trust. The revocable living trust means you can change or cancel it anytime you want. And most people start here. An irrevocable trust is permanent. You give up control, but you get protection from creditors and lawsuits. So, let's talk about Sarah. Sarah puts her house in a revocable living trust. She's still the trustee, she lives there, she controls it. But when she passed, her daughter automatically became the trustee and got the house immediately. No probate, no waiting, no fees. Only 15% of Americans have trust, and many think they're only for millionaires. But that's a wrong idea. If you own a home, you may benefit from a trust. Here's where most people's plans fall completely apart. What happens if you're alive but can't make decisions? A power of attorney lets someone handle your finances if you can't. If you're in a coma, bills need paying. The mortgage is due. Without a power of attorney, your family has to go to court and get a guardianship, which costs thousands and may take months. The most common type of power of attorney is called a durable power of attorney. It kicks in before you become incapacitated and stays in effect even after. So if Tom named his wife as his power of attorney, then has a stroke and can't communicate, his wife can immediately access bank accounts, pay bills, and handle his business affairs. Without it, she'd be in court for months trying to get permission. While a power of attorney handles money, a healthcare directive or a healthcare power of attorney handles your healthcare and medical decisions. These documents often have 2 parts. First, you have a living will, and that tells doctors what you want if you're terminally ill. You want life support for how long, decisions like that. Second, the healthcare proxy or healthcare power of attorney names who makes medical choices when you can't. So COVID taught us this lesson brutally. Healthcare directives spiked 5 times during the pandemic because people realized this isn't abstract. This happens. So Maria specified if she's brain dead with no chance of recovery, she doesn't want feeding tubes or ventilators. She says, my brother can make the healthcare decisions. When she's in a car accident and doctors need decisions, her brother knows exactly what she wanted. No guessing, no arguments. And here's the secret nobody talks about. Beneficiary designations on all your accounts. These designations override your will except for one thing I'll talk about in a second. You can write in your will, everything goes to my spouse. But usually if life insurance lists your ex as the beneficiary, the ex is going to get the money. Beneficiary designations control life insurance, retirement accounts, and bank accounts with payable on death designations. In Arkansas, and I think it's the only state, your will can redirect your life insurance money. So, for example, if somebody divorced and remarried but never updated their 401k beneficiary, passes, it will go to the ex-wife, even though his will said everything to the current wife and his children. Review these things annually. When you get married, divorced, have kids, or someone passes, update them immediately. Finally, how your property is titled matters as much as your will. Joint tenancy with the right of survivorship means when one owner passes, the other automatically gets it without probate. You can also retitle your deed to transfer ownership into your trust. That's part of funding the trust. A mistake people make is they create a great trust and then never retitle assets into it. If your trust isn't funded, those assets will have to go through probate. That's why a lot of plans fail, not because of taxes or bad law, but because of incomplete implementation. Here are the 6 essential documents: will, trust, financial power of attorney, health care directive, beneficiary designations, and property deeds. Each document does something the others can't. Most Americans know estate planning is important, but only about a third have actually done it. The gap isn't knowledge, it's action. So, the simplest start is to get a will and healthcare directive done. Those two will put you ahead of about 70% of people. Then add a power of attorney, review beneficiaries, and if you own real estate, think about a trust. Estate planning is a system, and you can build it one step at a time.